Hello, class. Welcome back. This is Professor Watson. This is LGLA 1351 contracts. And welcome back. This is week seven. Week seven. So we are on chapters 6 and 7 this week. We're going to put two of them together. I think that's doable. We're going to talk about those last two elements of contract. Remember, at the beginning of the semester, we talked about 4 or 5 elements, right? We talked about there were 4 elements of contract or 5 elements, depending on what you consider the last one. We're going to talk about those last two today. Okay. If you'll remember, the first one was an agreement, right? We had to have that meeting of the minds, offer and acceptance, all that kind of stuff. And then the next one was consideration, right? What you give for what you get. We talked about that. The third one was mutuality. We don't have a specific chapter on mutuality because we incorporated mutuality in that conversation about consideration, right? Mutuality, what you give for what you get. Both sides have to give something. Both sides have to get something. So the something that you get or give is the consideration. The fact that both sides to a contract, or if you have a multi-party contract, all sides to the contract have to both give and get something. That's the mutuality element. Okay. So the last two we're going to talk today, the last two we're going to talk about today are legality and capacity. And whether you consider those elements of a contract or conditions that just have to exist in order for a contract to be enforceable is really irrelevant. It doesn't really matter if we get that nitpicky, right? Just remember these 5 things you always have to have for a contract: an agreement, consideration, mutuality, and then the last two we're going to talk about today, legality and capacity. All right, so I hope you have already taken a look at chapter 6 and 7. Maybe looked over my class notes if that helps you, my lecture notes for today. Otherwise, let's go ahead and see if I can share my screen and let's get started on legality and capacity. Okay, let's see here. Share screen. There we go. All right, chapter 6. Um, Chapter 6 is on legality, right? Legality. What are we talking about? Well, you can see I've got there on the PowerPoint. It walks like a contract. It quacks like a contract. All the parties intended it to be a contract, but there's no way the court is going to enforce it because it's illegal, right? Well, that's what we're talking about: illegality. An otherwise enforceable contract will not be enforceable for illegality if well, we're going to have to think a little bit broader about the concept of illegal, okay? It is, a court certainly will not enforce a contract if it calls for a violation of a statute or another law, right? That would be per se illegal. All of us would say that's illegal, right? A court won't enforce a contract for illegality if the contract is formed in violation of the law. Okay, we might think of that as illegality too, right? If the law says you can't make contracts like that, you can't enter into contracts in that way, then all of us would say, okay, well, I see how that's illegal. Um, but the court is also not going to enforce a contract that calls for the commission of a tort. Remember, a tort; those are those personal wrongs or those civil wrongs, things that we don't necessarily think of as a crime, or though they're not crimes, they're torts. But we don't necessarily think of them as illegal. But a court is not going to enforce a contract that would require the commission of a tort either. And then lastly, it's kind of a catch-all category. The Even if it's not necessarily something we would consider illegal, the court is not going to enforce a contract. Sometimes, if the court deems that contract is against public policy, okay, that may sound kind of broad, and it is. It's kind of a catch-all. But we'll talk about all of these one by one here, okay? And then we'll talk about capacity as well. I think we can get that all done in one week. Um, Before we start, let me point out that when it comes to the issue of legality, even if a portion of the contract is illegal, that doesn't always mean that the entire contract is unenforceable. Okay? Let me say that again. Just because a part of the contract might be illegal or might be unenforceable due to illegality, it doesn't mean that the entire agreement is unenforceable. There may be situations where if the court can just cut out that illegal part, the court may still be able to enforce the rest of the contract. Okay, so you need to be aware of that. We'll talk about that more here as we move along. That first category, violations of well, what did we say on the first slide? Violations of a statute or other law. Okay, typically. Notice I'm saying not always, but typically, right? That's standard lawyer practice. We're always equivocating. We're always coming up with exceptions. We can't ever say anything is just definite, right? We always have to be careful about that stuff. But typically, if a law violates a statute, then a court is not going to enforce the contract, or at least not enforce that provision of the contract. But sometimes that's not always the case. Let's take, for instance, the situation with licensing laws. Okay, licensing laws. There's there's thousands probably of laws out there that require licenses for certain things, right? You have to have a license to drive a car. You have to have a license to be a lawyer. You have to license to be a doctor. And if a licensing law is meant to protect the public, okay, if a licensing law is meant to protect the public, then an agreement that is in violation of that licensing law will be unenforceable. Okay, so there's laws that require lawyers and doctors to be licensed, right? This is to prevent the public from being harmed by unlicensed or uneducated physicians, right? It is a way to prevent the public from being harmed by unlicensed lawyers or from people who don't know what they're doing, right? Therefore, if you enter into a contract in violation of one of those statutes with someone, you enter into a contract with someone who is not licensed, then that contract is likely to be is going to be unenforceable, right? So if you enter into a contract with a doctor um, fill in the blank, take out your appendix, stitch up your arm, fix your broken leg, but it turns out they're not actually a doctor, then obviously the court is not going to enforce that contract, right? That may sound crazy, but you may remember here in Texas, just a couple of years ago, we had a contract with a lady who was doing, a lady and a guy who were doing filler injections in the back of a nail salon, and they were apparently shooting up some woman's rear end, right, with silicone. But they were shooting up with silicone that they bought at Home Depot, not what we would consider a medical grade product. They were not doctors, right? That unfortunate victim died, and it was terrible. But if that victim had realized these people weren't doctors beforehand, and had said, well, I'm not paying you, and they had tried to sue her to pay them because she entered into a contract, of course, the courts would say, no, you're not doctors. We're not going to make her pay you for medical services that you're not allowed to perform. Okay. So if the statute, if the licensing statute was designed to protect the public, then contracts that violate that statute are unenforceable. Okay, but as I mentioned, there are hundreds, if not thousands, of different licensing laws, right? Yes, you have to have a license to drive a car. Yes, you have to have a license to be a doctor or a lawyer. But there's also licenses like, did you know that in Dallas you have to have a license or obtain a permit in order to have a garage sale, right? What is that about? It really doesn't cost very much. It's a very small fee. They hardly ever enforce the law, quite honestly. What is the purpose of that law? Are we trying to protect the public from nefarious garage sales? No, it's a revenue raising stream, right? It's a revenue raising stream. So if a licensing law is primarily to protect the public, then the court's not going to enforce a contract that violates it. But if the licensing law is primarily designed to raise tax revenue, then a contract that violates that law will probably be enforceable nonetheless. Okay. So if I don't get a permit to hold a garage sale, and you come to my garage sale and you really like my treadmill, right? There's always treadmills at garage sales. You come to my garage sale, you want to buy that treadmill. You can't fit it in your car right now, but we enter into a contract. I'm going to sell you that treadmill for $100. You're going to buy that treadmill for $100, and you're going to come back by the end of the day tomorrow to pick it up. And you don't come back by the end of the day tomorrow to pick it up. So I decide to sue you in small claims court for that $100. Can you defend yourself and say, no, that contract is illegal because you didn't have a garage sale license or garage sale permit? The answer is no. In that situation, that statute really isn't about protecting the public. It's about raising tax revenues, right? And so a contract that would be in violation of that statute still may be enforceable. Okay. Now, the party who didn't get the permit or the license, they may be subject to some kind of civil penalties from the government, but that's between them and the government. That contract will still be enforceable because the violation, the court enforcing that contract doesn't really cause any harm, right? It's not doing anything that harms the public or could lead to harm from the public. Whereas if the court tried to force you to pay a doctor who's not really a doctor, or tried to force you to have a surgery from somebody who's not really licensed, never went to medical school, that could cause serious injury, right? Okay, so generally speaking, if a contract would violate a statute or other law, it won't be enforceable. But there are exceptions, like licensing laws, Okay. Um, there are other kinds of laws, though, that you may need to be aware of. And contracts that violate these kind of statutes may not only be unenforceable under the common law, these statutes themselves may have additional penalties or additional provisions. And so you need to be aware of them. One type of these laws are usury laws and other lending laws. What is a usury law? USURY, usury. Usury is the lending money at an illegally high rate of interest. Did you know that states most of the time have a law that says there's a maximum interest rate you can charge when you loan money? That's where we get terms like loan sharks from, right? Loan sharks are people who typically charge usurious rates. Those high rates of interest are illegal, and states often have statutes that prohibit that. So usurious is just the adjective, right? That's the adjective form of usury. Usury is the verb. Usurious is an adjective, and it describes a contract that charges an illegally high rate of interest. Contracts that violate usury laws are typically going to be illegal. They're unenforceable under the common law, but you also need to check those statutes. Sometimes those statutes have additional teeth, not only might the contract be unenforceable, but under usury laws, typically the lender forfeits the capital, right? So if somebody loans you $1,000 and they want to charge 50% interest per year, that's almost always, if your state has usury laws, 50% is way too high. And in a lot of laws, not only will that contract be unenforceable, I don't owe you the 50% interest. But if you look at those statutes, a lot of times I don't even have to pay the $1,000 back. Tough luck, buddy. So I hope you're not a loan shark. There's people who come and break my legs and those kind of things, because I'm not paying you the money back. It's usurious. All right. There's lots of other lending laws too, though, right? Lots of like consumer loans, right? We have a lot of laws that involve consumer loans to individuals, loans that don't involve a business, or maybe don't even involve a regulated bank, right? We have all these payday loan places, even pawn shops, right? Even credit cards in some states. There's typically a lot of statutes that regulate consumer loans and payday loans and even credit card interest and those kind of things. And if you look at those laws, typically if you have a contract that violates those laws, those contracts are going to be unenforceable for illegality. Now, just like the usury laws, you need to check those statutes if they apply, because they may have extra provisions. It may be not only is the contract unenforceable, not only does the person maybe not have to pay the money back, but there can be bigger teeth too. They may be able to sue for additional civil penalties. They may be able to keep the capital. There may be even fines that you have to pay the state and those kind of things. But consumer loan laws, those kind of things, you need to check those, because if a contract violates those type of statutes, then the contract is typically going to be unenforceable for illegality. All right. Now, those statutes, every state has some, but they can be very different from state to state. So make sure to check your jurisdiction and check the applicable statutes to see exactly what the law is on usury in your jurisdiction, or exactly what the law is on consumer loans or payday laws. Or again, some states have laws on how high an interest rate you can charge on credit cards. Those are becoming higher and higher. It used to be the states that had very low limits on interest rates for credit cards. Well, the people in their states had a real hard time getting credit cards. So some of that is changing, but beware, check your statutes. Okay. Often there are other regulations as well, right? Like the FTC, the Federal Trade Commission, and other federal agencies. There may be related statutes, but again, these agencies typically have rulemaking authority, so there may be regulations as well. that limit certain aspects of loans and lending, right? There's all kinds of statutes that govern national banks. There's all kinds of statutes that govern mortgages, those kind of things. And so you need to be aware of those. And a statute that a contract that violates those statutes may be unenforceable. So if you are representing the lender, especially, you want to be familiar with those laws to know if this contract that you're entering into is going to be enforceable. I mean, after all, you don't want to loan somebody a bunch of money and then find out that at best you're not going to get your interest back, right? At best, you just let them use your money for a while and then you get your money back, but don't make any kind of profit. You took all the risk and no profit. And be careful because, in addition, like I said, some of those statutes may have additional teeth, right? Like you may lose your capital, or there may be additional penalties. So you need to know about those. On the state side, remember we have the federal government, we also have the state government. On the state side, there may be state banking laws and similar regulations, right? There may be state laws that require certain kinds of disclosures that need to be made with certain types of contracts, right? You'll have to check your law. A contract that is made in violation of that statute may be unenforceable. Okay. There are typically state regulations that regulate things that you can put in contracts. The regulation, the forming of the contract, right? One of those is something that we would call a confession of judgment, right? It is, or at least it used to be common for if you were entering into a contract with somebody, you're looking down, you're planning, you're looking down range, and you're thinking, okay, if this guy breaches the contract, what am I going to do? I'm going to have to sue him, right? And so let's just while we're drafting this contract, let's just cut that off at the pass. Let's do it all right now. I'll tell you what. In this contract, we'll put in a clause that says if you don't pay me, then I don't have to sue you, or if I sue you, you're just going to confess a judgment. And in fact, you'll sign that agreed judgment right now. We don't have a case number yet, but I'll sign a judgment right now that says, you can start enforcement mechanisms. You can, take my house or foreclose on my property or whatever, even without going to court, because I've already signed a judgment. So if I breach the contract, you can file a suit real quick, enter this agreed judgment. You never even have to serve me. It's just over, right? And as you can imagine, that sounds a little abusive, right? That can be taken advantage of. And so there are often state statutes that say that's going too far. That's illegal. We're not going to put a confession of judgment. We're not going to enforce a confession of judgment clause in a contract. It's illegal. We're not going to enforce that part of the contract for illegality, okay? Gambling. Right, gambling is regulated by statutes in every state. Right, every state has at least some type of laws regulating gambling. Some states just outlaw virtually all gambling, although most states allow at least a little bit. Some states allow fairly open gambling with regulations. Right, so in Nevada, right, you go to Vegas, they're all about the gambling. So how do we handle that? Well, typically a contract that violates the gambling statutes is unenforceable, okay? So if your state has a law that says gambling is illegal and you have an illegal poker game and somebody welches on a bet, can you sue them for breach of contract? Can you sue them for breaching that bet? You might not think of that as a contract, but it is. It's a conditional contract, right? Just like your insurance. We could think of your insurance as gambling, right? The insurance company is gambling that you don't have any wrecks. And if you do have a wreck, they have to pay out. Well, gambling can be, we could get crafty and we could write up a contract that looked very much like an insurance agreement, but was really gambling. And gambling contracts, if the state outlaws gambling, then the state is not going to enforce any kind of gambling debt or gambling contract, okay? Why do I bring that up? Is that really such a big problem? Not that much. I don't suspect many of you are going to have clients who come in with gambling contracts. And if you do, it's probably because you're in a criminal lawyer's office, right? And you're not worried about the contract law. Now you're worried about maybe keeping your client out of jail because that's how it's come up. But the thing is, you need to be aware of them because sometimes there are things that look like a contract and they look like business, but they may fall under the purview of those gambling statutes, okay? Things like pyramid schemes, pyramid schemes may be deemed illegal as gambling. Do you know what those are? That's kind of where, one person says, okay, if the five of you, pay me a fee to join in here and become members, then you go out and each of you sell, five memberships and they pay you a fee, and each of them go out and sell five memberships and pay them a fee. See, we're really not creating anything. It's just a pyramid scheme. As long as we can get more people to join in, then everybody up the pyramid makes money. But eventually you're going to run out of people, right? And eventually somebody gets left holding the bag and somebody owes a lot of money, and you're not really doing anything. It's just gambling. In some circumstances, it may be difficult to discern between what is an illegal gambling contract and what is, on the other hand, maybe a completely enforceable insurance contract, right? And the question is usually, when you run into those things, is the enforceability, whether it's going to be enforceable or whether it's going to be declared unenforceable because of illegality, right? Turns on whether there is some legitimate or insurable interest, okay? So a legitimate if there's a legitimate financial interest that's the subject of the contract, then that's probably insurance. But if you have no legitimate financial interest, no insurable interest, the courts would say, then the court may see something as merely gambling and therefore unenforceable. Let me give you an example. Your company may have a perfectly legitimate reason to take out a life insurance policy on your CEO, right? If your CEO dies, that can have a great effect on the company, the price of the stock, and all those kinds of things. So taking out a life insurance policy on somebody else's life may be very important to you. You may have a legitimate business interest there. But what about these death pools or dead pools, right? What about those? Do you have a legitimate interest in ensuring the life of Tom Brady or Bob Barker, right? No, right? You're only playing the odds, right? You're betting that you're hoping that if I bet on Bob Barker that he's going to die this year, and then I'll win the pot, right? Or I'll get the insurance. You don't have a legitimate interest in ensuring Bob Barker or Tom Brady's life. The football team might, the TV network might, but not you. And so if you have an insurance policy, you may be trying to play the odds, and you may go to a real life insurance company, and you may try to take out a life insurance policy on Bob Barker or Tom Brady. But understand that if they take your money, and Tom Brady dies, they're probably not going to pay out. They're going to come back later and say, oh, you know what? I'm sorry. You didn't really have any insurable interest there. So tough luck. Those kind of things you may want to know, right? So be careful. Some things may look like legitimate contracts, but if they edge over into that gambling, they may be unenforceable due to illegality. All right. That leads us to something called blue laws. Are you aware of what blue laws are? Blue laws are sometimes called Sunday laws, or some people view them as morality laws, right? Blue laws typically prohibit certain kinds of transactions on Sunday, okay? They are becoming less common as our country becomes more diverse, as organized religion wanes in some areas, as commerce becomes more important, perhaps as commerce becomes our religion. Sunday laws or blue laws are becoming less common, but they still exist. And what do they look like? Well, they're often things like you can't sell alcohol, or you can't sell cigarettes on Sundays, right? Or you can't sell alcohol or cigarettes before 2 o'clock on Sundays, right? Everybody's supposed to be at church, not smoking and drinking. Those kind of things. Those are blue laws, Sunday laws, sin laws, morality laws. Typically, you need to check those statutes, but typically agreements that violate blue laws are unenforceable as illegal, right? I mean, that's the whole purpose of the statute, is to keep people from doing certain things on Sundays. And so if you contract to do something on Sunday, and that violates the blue law, the court is not going to force you to do something that violates the law. That was the whole purpose of the law, was to keep you from doing it. So beware the blue laws. A contract that violates a blue law is typically unenforceable for illegality. All right, what about torts? We've talked before about sources of law, and about how there's criminal laws, and then there's tort law, and typically we say things, murder and assault and theft, right? Those are illegal because they violate criminal laws. And of course, any contract that called for violation of criminal law would be unenforceable as illegal, right? So if I hire you to kill my brother, right, and you don't do it, I'm going to have a hard time suing you in court because the court is never going to enforce a contract that calls for the commission of a crime, right? They're not going to force you to kill my brother. They're not going to force you to rob a bank. They're not going to force you to break somebody's arm. And if you do rob a bank or break somebody's arm or bump somebody off and you don't get paid, you better get paid up front, because if you don't get paid up front, the court's not going to force that contract and make you pay your hitman, okay? Because those would clearly violate penal laws. Those are clearly illegal. But that brings us to torts, right? We typically don't think of torts as illegal. Those are those private and those civil wrongs, things like negligence, right? But you can also have torts that look like criminal laws sometimes, right? Like we have the crime of assault, we have the tort of assault, we have the crime of battery, we have the tort of battery. And so a contract that calls for a commission of a tort is probably also going to be unenforceable due to illegality, okay? Let me see if I can pop that up. Let me give you an example. Well, a tort is a cause of action that gives one person or one entity the right to sue another person or entity for damages. And if a contract calls for the commission of a tort, even if that tort is not per se illegal, even if it's not a crime, the contract is going to be unenforceable for illegality. So let's say Donald Trump has been whacked a couple of times, right, for committing the tort of slander, right, of defamation. He has been convicted twice of slandering an author named E. Jean Carroll. And the last time he got hit with a pretty big punitive damage award. And maybe he's finally learned his lesson. He doesn't want to do that again. So instead of doing it himself, he hires a bunch of influencers, right? And he says, hey, I'll pay you guys to go out and slander E. Jean Carroll. If they go out and they slander E. Jean Carroll and they come to him looking to get paid, the court is not going to enforce that contract because that contract called for the commission of a tort. Maybe if we think about it the opposite way, it seems more ridiculous, right? If they don't slander E. Jean Carroll and Donald Trump tries to sue them and say, hey, you were supposed to go out and slander E. Jean Carroll, the court's not going to force them to do that, right? Because it would be illegal. It would be not per se illegal. It's not a crime necessarily, but it would be a tort. And the court's not going to force someone to commit a tort or force someone to pay for the committing of a tort. All right. A contract might also be illegal, even if it doesn't necessarily violate a statute. Maybe I should take the violation of statute title off of this slide. On the grounds of public policy, okay? Court may find a contract illegal on the basis of public policy. That's where maybe there's not a criminal law that this contract violates. Maybe there is not even a tort being committed, but the court decides that, you know what, this is just not the thing courts are ready to enforce. And so the court may choose to refuse to enforce a contract based on illegality because otherwise trying to enforce the contract might violate public policy. What kinds of things violate public policy? How do we know? Well, you're going to have to check your common law for that, right? I mean, if it was in a statute, then we would know. It would be a statutory violation. We have a law right there that said, no, don't do it. These kind of public policy concerns typically pop up in cases that actually happen, right? And where the court goes, man, I don't know what to do about this, but I don't think I can enforce this contract because of public policy. I think an example I gave a couple of weeks ago works here too. Contracts for adoption, right? A young woman is pregnant, maybe she's single, maybe she's married, but she doesn't think she can have the child, or she doesn't think she's up for caring for the child. She's just trying to decide what to do. She may enter into a contract with another family, right, that really wants a child. And that may sound like a good thing. But are we going to, what happens after the fact? After the child is born, if the birth mother decides that she no longer wants to give the child to the adoptive family. She doesn't want to go through with the adoption anymore. Is a court going to take her biological child away from her and give her to the other family? We can make that even a little trickier, right? What if she's just a surrogate? What if she has no biological connection to it at all, to the infant at all? But she carried it. Is the court going to take that child away from the birth mother and give it to the other family? That's an area of law that's very interesting, and it's changing, right? As we become more involved and more complex ourselves, and as these things become more common, and as science becomes more capable, we are adopting statutes on these things. But until the statutes make it clear, a lot of times the courts will punt on those and say, you know what? I can't enforce this. I can't enforce this contract due to illegality, due to public policy. Right? There may be nothing illegal. There's nothing tortious about entering into a contract to support a pregnant woman and to adopt her child after it's born. In fact, that sounds like a good thing. But it may look like a contract. It may be a superbly drafted contract. But after the fact, now that the child's here, somebody's changed their mind. Is a court going to enforce that contract? I don't know. Maybe, maybe not. But if they don't, they may not enforce it because they're going to fall back on this public policy argument that enforcing this contract would be contrary to public policy. All right, that's just an example of one of those types. That public policy is really a big, kind of a catch-all for when the court isn't sure why else not to enforce a contract, but they don't want to do it, right? All right. Some other terms that you may see in a contract. Let's get to some let's get some definitions out of the way. An exculpatory clause. What is an exculpatory clause? An exculpatory clause is an agreement in a contract that attempts to exempt someone ahead of time for their own potentially tortious contract. Okay. If you want to hire me to do something, you want to hire me to do some electrical work on your house, right? We sign a contract. You're going to pay me $1,000, and I'm going to change out your electrical panel. But I'm going to put in that contract that, but if I burn your house down, you can't sue me for negligence, right? That would be an exculpatory clause. And that one would be pretty egregious, right? We might have a number of illegality issues with that contract. Number one, because I'm not a licensed electrician, right? I'm a lawyer. And we have licensing laws that say electricians have to have licenses, and I don't. So that may be right there one reason why the contract shouldn't be enforceable. But what if I do have an electrician's license? But I've got this exculpatory clause that says if I screw up and burn your house down, you can't sue me. Is that fair? Well, that one sounds like, probably not, right? That doesn't sound anything fair. That doesn't sound like there's anything fair about it. But these kind of clauses pop up more often than you would think, and often for good reasons, right? Often because without an exculpatory clause, one party wouldn't be willing to enter into the contract in the first place, right? And so sometimes exculpatory clauses are actually very valuable. They're the only thing that permit the parties to follow through with a contract that they really do want to enter into, and that may actually do a lot of good. So what are the rules on exculpatory clauses? Well, exculpatory clauses are not always unenforceable for illegality, but they may be. How do we determine if they are or not? Well, typically, if an exculpatory clause just seeks to excuse negligence, right? If it just seeks to excuse merely negligence, then it's more likely to be enforceable. Okay. Whereas an exculpatory clause that seeks to excuse reckless or intentional conduct, more likely to be unenforceable, right? And you can imagine that, right? Let's say we want to play football. Football can be a violent sport. It can be dangerous, right? And so if we sign a contract that says, "Hey, I will release you ahead of time from if you hurt me through negligence," right? And you'll release me in case I hurt you through negligence. That way we can both play football, and if somebody gets hurt, we're not too worried about lawyers and insurance and all that kind of stuff, right? But But what if that release said, I release you not only from if you negligently hurt me while playing football, um, what if that contract said, I release you if you intentionally hurt me while we're playing football? Well, what are you going to do now? At that point, if there's a contract that says, I release you from any damages you do if you hurt me intentionally while we play football, well, you're going to target me, right? I mean, you're going to stomp on my head when I'm down. You're going to try to break my leg in the scrum, and because there's nothing stopping you, right? So exculpatory clauses that seek to excuse intentional conduct or even reckless conduct, right? If you've taken torts or personal injury, you remember there's negligence. That's something that a reasonably prudent person wouldn't do, but those are mistakes and accidents, right? Where intentional, that's things that you intended to do, or that you at least you intended the action or you intended the outcome. And recklessness is in the middle, right? Recklessness is where you're consciously aware of an extreme risk or of a risk of extreme injury, and you do it anyway. So exculpatory clauses that seek to excuse negligent conduct, those are more likely to be enforceable. Exculpatory clauses that seek to excuse that intentional or reckless conduct, typically not going to be enforceable. Okay. Um, um, and that public policy may come up there again, right? If you don't already have if your jurisdiction doesn't already have multiple cases on exculpatory clauses, and they all do, but if they don't yet, then they may talk about public policy. They may talk about the public policy of giving somebody a free pass to do something wrong, right? We can't encourage that, but we may allow clauses that excuse negligence, right? Courts treat those exculpatories that would excuse negligence. They still treat them with a bit of skepticism. They still look at them a little more carefully. But they may treat negligence differently because exculpatory clauses for negligence may have some positive effects, right? They may have good purposes. There may be reasons that we want those to be enforceable. But typically, the courts are going to look at a number of standards when they judge whether or not an exculpatory clause for negligence is enforceable. They may look at things, and again, you'll have to check your jurisdiction. Every jurisdiction's law is a little bit different. But here are some of the common elements that you're often going to see in those cases dealing with. Is an exculpatory clause that excuses negligent conduct, is it enforceable? One of the first things courts are going to look at is, was that exculpatory clause conspicuous and clear, right? You'll see clear and conspicuous and clear. You'll see that language pop up a lot. What do we mean? We mean, was it something that everybody could see, or was it something, hidden in the fine print on page 47 where nobody saw it, right? If you go to the fair to a football game and you park in their parking lot, right? You pay $20 to park at the fair, and they give you a ticket. You put it on your dashboard, and while you're at the fair, somebody breaks into your car, and they say, "Ha ha ha! You can't sue us because on the back of that ticket there's this exculpatory clause." Well, is that clear and conspicuous? You didn't even know it. How could there have been an agreement? How could there have been a meeting of the minds if you didn't even know it was there? So whether or not the exculpatory clause is clear and conspicuous is usually one factor the courts will look at. Okay. Second factor is, was it an arm's length transaction? Did the parties actually bargain for this? Was it something that they discussed? Or was it something that was just kind of crammed down their throat, right? If it was an arm's length transaction, if it was a legitimate, actually bargained for exchange, if it was a legitimate discussion, then a court is more likely to enforce an exculpatory clause for negligence. The court may also look at the bigger picture. The court may look at to what degree could either party protect themselves from the risk, right? If one party is far more capable of protecting itself against the risk, then it may be fair to excuse the other side for negligence, right? They may look at, was the risk obvious? Was the risk within the control of one party or the other? Is this a fair attempt to allocate that risk? Or is this just an unfair attempt for somebody with more bargaining power to get out of responsibility, right? So these are all things that courts are going to look at when judging whether or not exculpatory clauses are enforceable. Again, if it's for reckless or intentional conduct, court's probably not going to enforce it. But if it's for negligent conduct, then the court is still going to look at it carefully to see whether or not it's enforceable. Why would you ever want to allow those? Well, what about I need to have open heart surgery, and I'm making these numbers up. Don't be afraid of doctors. I'm not trying to slander hospitals. Let's say I've got to have some kind of terribly exotic surgery, and I've only got a 20% chance of surviving that surgery. But if the surgery is successful, I can live another 50 years. Whereas my chances of surviving without the surgery are zero, right? Is that a chance you're willing to take? It's a chance I'm willing to take, right? If I'm the patient, a 20% chance of living is better than no chance of living. But what doctor is going to agree to do surgery, right? What doctor is going to agree to do surgery if there's an 80% chance that you're going to die on their table, and then you're just going to sue them, right? So that release there would be an exculpatory clause where they say, but you can't sue me for negligence. I'm going to do my best, but maybe you can't sue me for negligence. Or what if you want to go whitewater rafting, right? Whitewater rafting, inherently dangerous. And so if you try to, they're going to have you sign a contract, right? Sign a waiver and that kind of stuff while you're there. And if that contract says, if the guide hits you with his paddle and dumps you out of the boat on purpose, you can't sue him. That's intentional conduct, not going to be enforceable. But if it says, we can't be held responsible for negligent conduct, this is an inherently dangerous business, then they may not be willing to take you, right? I mean, you may not be able to go whitewater rafting unless you're willing to waive claims for negligence, right? And so if we think whitewater rafting is a benefit, that's a plus, that's something we want to do, then allowing people to waive negligence, to sign exculpatory clauses that will be enforceable, maybe that's a good thing. Okay, so exculpatory clauses may or may not be admissible. We would lump that under this idea of illegality, not because they're per se illegal, not because somebody's going to go to jail, but really more on kind of that public policy grounds. Is this a good thing? Is this the way? Is this something we want people to be able to do? And again, the decision is generally not for intentional or reckless conduct. We're not going to excuse that kind of conduct. And if you have a clause in a contract that says we're excusing intentional or reckless conduct, the court's going to say, nope, at least I may be able to enforce the rest of the contract, but I can't enforce that clause because of illegality or because of public policy. Whereas if the exculpatory clause just excuses negligence, the court's going to say, all right, well, let's talk about it, right? Let's look at these factors. And there's not one single factor that's going to make a difference, right? It's not one single factor, it means yes or no. It's not like if you can't prove one of the factors, that the court's automatically going to say, okay, I can't enforce it. But the court is going to weigh those factors and say, is this something then that is in society's best interests, or is this something that I should not enforce? Typically, the courts aren't going to make that decision themselves anymore because it's a matter of common law. You can look up the cases in your states to see what the courts will and will not accept as far as an exculpatory clause goes. All right, continuing on with illegality, contracts that are in restraint of trade, antitrust contracts, we might call them. Contracts that are in restraint of trade, typically not in the public's best interest. And so typically, they're at least going to be suspect. Now, will courts enforce contracts in restraint of trade? Maybe, but there's going to be a balancing act. They're going to look at it very carefully. We can start with this general concept that, at least in this country, our public policy is that a free market, right, a laissez-faire economy benefits everybody, and that our economy only works if we have unrestrained trade. So, covenants not to compete, right, they hamper that. In other words, our idea of laissez-faire economics in the United States is that the more people we have competing in a particular area, in a particular industry, the better, right? And the really good one, the people who can make the better mousetrap and sell it cheaper, they're going to rise to the top. And the people who build a worse mousetrap or more expensive, they're going to fall out of business, right? And that's a continuum. Just because one person rises to the top doesn't mean they can't be replaced the very next day with somebody else who built a better mousetrap. And that competition benefits the public. It gives us better products. It keeps the prices down. And it only works if competition is free. From the manufacturer's perspective, though, they would really like to have no competition, right? If I've got no competition, I don't have to make a very good product, and I can sell it for as much as I want, right? I'm the only game in town. If people want a mousetrap, they're going to have to buy my lousy mousetraps because there's no other mousetrap manufacturers. And so it is in my best interest if I can't put my clients out of business just through better business practices. Maybe I can pay my clients to go out of business, right? And that's where we get the concept of things like monopolies, right? A monopoly is somebody who's come in and just completely taken over a particular area, a particular industry, right? There's just no other options. And maybe they've done that through their own good business, or maybe they've done that through restraint of trade, through antitrust agreements, through contracts that put people out of business, right? So a covenant not to compete is a contractual way to restrain free trade. Are the courts going to enforce them? The answer is not generally, but sometimes, right? Sometimes, even though it seems counterintuitive, sometimes a restraint of trade is really beneficial to society. So that the general rule is that restraints on trade are generally disfavored, but not always. So, okay, how do we know if a court is going to enforce restraint of trade or not? Well, again, do the research on the common law in your particular jurisdiction, but generally speaking, the courts generally do the same thing. They're going to look at, it's going to be a balancing test, right? Again, another one of these balancing tests where there's not one single factor that is going to decide the case, but the court is going to look at this balancing test. The first thing they're going to look at is this restraint of trade the part of some kind of larger legitimate contract? Okay. Let me give you an example. I'm a dentist. You're a dentist. I would really like for there to be less dentists in Dallas, so I just pay you to go out of business. Is that connected to a larger legitimate contract? No, that's just restraint on trade. That's just me paying a competitor to go away. Not going to be enforceable. But could it be part of a larger legitimate contract? Sure. What if I'm a young dentist and you're an old dentist and you're getting ready to, you want to retire, but you don't want to just shut down your doors and get nothing for it. You'd like to try to make a little money off of that. And I'm a young dentist. I don't have any customers yet. I don't even have a store or an office yet. What if I buy your practice from you? I buy your location. I buy your rooms. I buy your client list, right? Your patient list. That could be very valuable to me. That could help me get started. But it's only valuable to me as long as you actually retire. It's not valuable to me if the next day you just open up another dentist office next door and all of your patients would just come next door, right? So if I am entering into a contract with another dentist just to buy them out of business, not part of a larger contract, not going to be enforceable. But if I am purchasing your practice, right, because I want to expand my practice or grow my practice, then I might want a covenant not to compete. So that to protect the value of what you're selling me, right? You may want to enter into that covenant not to compete because the only way you're going to get top dollar is if you can promise not to compete against me, right? So you want that to be enforceable as much as I do. And in that situation, part of a larger contract, probably enforceable. All right. Next thing is the court is going to look at is the exculpatory clause reasonable in scope? All right. And there's typically three different things they look at. So I always put reasonable in scope times 3. There's 3 scopes. The court wants to know, is this covenant not to compete reasonable in the scope of time, right? Is it reasonably short? Is it way too long? Is the time limit here reasonable? They're going to want to know, is it reasonable in scope of geographic limits, right? Where does it cover? And they're going to look at, is it reasonable in scope of the business activity limited? All right. It is worth memorizing these because even though, like I said, the case law may be different in every jurisdiction, this is something that is very similar. Reasonable in scope times 3 is something you're going to see in just about every jurisdiction. Let's consider them. So how about Howard Stern, right? A disc jockey. You want to hire Howard Stern to come work at your radio station because he brings in a lot of listeners, and that would be great. And you're going to promote the heck out of Howard Stern being there. But you don't want to do that if he's just going to leave 10 minutes later and go to another radio station, right? So you might enter into a contract with Howard Stern that says, yeah, I'll pay you, $1 million a year, $10 million a year, whatever he's worth. But you agree that if you quit, you won't go to work for another radio station for some period of time. What period of time would be reasonable? Well, it's going to be up to a jury, but would 6 months be reasonable? I think so, right? It would take you at least 6 months to get another show off the ground. So keeping Howard Stern from saying, "I'll pay you a bunch of money if you promise not to go to another radio station for 6 months if you quit here," that's probably reasonable. What about a year? Maybe. What about 6 years? Oh, I don't know. What about 60 years? What about 600 years? Well, 60 or 600 years, that's just basically his entire life. What legitimate interest do I have in keeping Howard Stern from being on the air, 60 years from now, or even 10 years from now, right? It's just whatever competitive advantage he would have had is gone by then. So the restriction has to be reasonable in scope of time. Also has to be reasonable in scope of geographic limits, right? If I said Howard Stern can't go work for another radio station anywhere in the United States, that's probably reasonable, right? Because he's syndicated right now. You can get Howard Stern all over the United States. If I'm hiring him and I'm paying him the big bucks, it's because that's the market I'm buying, right? But what about if I hire you to work at Chick-fil-A, right? You're going to be a cashier at Chick-fil-A. And before I hire you, I say, okay, I'm going to pay you this much an hour. We're not going to work on Sundays. And if you quit, you can't go to work for any other chicken restaurant in the United States, right? Is that reasonable? What interest do I have? How would it affect my business if you go work for another chicken restaurant in Los Angeles, right? It just doesn't. That's not reasonable. If you go work for another chicken restaurant next door, or you go open up a chicken restaurant next door, well, then maybe that's reasonable. But what interest would I have, and how would it affect me if you want to go work in Los Angeles or even Waco, or even with a chicken restaurant, even the south side of Fort Worth? How does that affect me? So the restriction has to be reasonable in scope of time, but also in geographic limits. Okay, and that Chick-fil-A example may also be a good example of this last one. In scope of the activity limited. All right. So if you're working for me at Chick-fil-A and I have you sign a contract that says, hey, you won't go to work for any other chicken restaurant for 1 month within the east side of Dallas, right? That might be reasonable. Maybe there's some reason. I don't want to give away all my secrets, or I don't want to teach you to cook chicken as well as I do. And so if you don't go to work for somebody else for a month, on this side of Dallas, selling chicken, maybe that's reasonable. But what if I say you can't take any job, right? You can't sell shoes, you can't sell hamburgers. Was that, regardless of how limited the time, regardless of how limited the geographic scope is it reasonable to prohibit you from selling hamburgers if I run a chicken shop, right? How is that a competitive disadvantage to me? So in order to be enforceable, these restraints on trade, these covenants not to compete, they need to be reasonable within scope, right? Reasonable within scope times 3. They've got to be reasonable in scope of time. They've got to be reasonable in scope of geographic limits, and they need to be reasonable within the scope of the activity limited. Okay, so reasonable in scope times 3. Now, if the court looks at that and says, yes, this is part of a larger legitimate contract, and yes, these terms do look reasonable, then typically a court may enforce that provision, even though it's in restraint of trade, right? And again, you can see how that might be beneficial. If you want to, let's go to back to our dentist example. If you want to sell me your dental practice, you're retiring. You want that to be as valuable as possible, but I'm not going to pay you for it unless I can make sure you're not just going to jump right back into business and take all your customers back, right? So I want it to be enforceable. You want it to be enforceable so that you can get the most for your money. We're all better off if it's enforceable, right? So as long as it is part of a larger agreement, reasonable in scope, then typically a court will enforce covenants not to compete. Other restraints on trade. Again, they're going to the court's going to examine all of those elements. There's not one necessarily that is enough to say it's unenforceable. There's not one that's necessarily enough to say that it is enforceable. The courts are going to look at the type of agreement, the purpose of the agreement, what legitimate business interest you're protecting, right? Talking about that chicken restaurant. If you want to leave and go work at a donut shop, how does that affect my chicken restaurant? They're going to look at the relative bargaining powers. They're going to put all of these things together and consider kind of the public policy and the interests of the public at large. And if they're reasonable, then the courts may enforce them. And if they're not, good luck, because the court's going to strike through those. All right. So these exclusive dealings, covenants not to compete, and things like exclusive dealings contracts. Remember we talked about those, I think, last week. An exclusive dealings contract would be something like, I'm only going to buy my fill in the blank. I'm only going to buy my supplies of this from you, right? Or I'm only going to sell this to you. Or you might have it like a representation group, right? Tiger Woods. Tiger Woods is only going to advertise shoes for Nike, right? He's not going to advertise for anybody else. That's an exclusive dealings contract. Those kind of things you got to analyze carefully. Not only are you going to be looking at the kind of the common law ideals that we just talked about, but you need to be aware that when you get into areas of restraint of trade, that you may run into things like antitrust laws. Those are federal laws that prohibit monopolies, and they prohibit practices that would lead to monopolies. And so even if it is reasonable, those kind of exclusive dealings contracts, you're going to need to look at and see, do they violate those antitrust laws? Because if not, if they do violate those antitrust laws, they're going to be unenforceable for illegality. All right. Okay, so anyway, 5 minutes, and then we'll stop this recording and we'll try to move on. So what happens if we have a part of a contract or something in a contract that looks like it's illegal or looks like it's unenforceable for illegality? Maybe it violates a statute. Maybe it's usurious, right? Maybe it's just it calls for tortious conduct, right? Or maybe it's one of these covenants not to compete. I'm not going to go into every detail, but even if a portion of the contract is unenforceable, okay, that may not render the entire contract unenforceable. All right. In some cases, courts will look at it and they'll say, look, if we can take out that illegal portion and then enforce the rest of the contract, then we're going to do that, right? We'll just ignore the unenforceable part. We'll just ignore the illegal part, and we'll honor the remainder of the contract. Okay? So the question is, can we cut out the bad part and still enforce the contract? Well, in some situations you can, in some situations you can't, right? And in some situations, if you cut out the illegal or the offending portion, it just destroys the whole contract. In other situations, you may look at it and you go, well, that's just a small part. If we take that out, then the contract can still be enforced. Both sides can still follow it, and the contract will still meet its essential purposes, right? Well, if that's the case, then we would say that illegal or that offending portion is severable, meaning that we can cut it out or removing it without changing the essential purpose of the contract, right? So you hire me to work at your Chick-fil-A restaurant. I agree to work for you for minimum wage, and I sign an exculpatory clause that says I won't work for any other restaurant in the entire United States for the next 50 years. Well, is that contract enforceable? Sure. The court is going to sever out that covenant not to compete. The court's going to sever out that covenant not to compete and say we can still enforce the rest of the contract. This is really an employment contract, right? You need somebody to work for you. I need a job. So we can enforce the rest of this contract. We'll just cut out that illegal covenant not to compete. Or an exculpatory clause, right? If we sign a contract that says, hey, I'll do some work for you around your house and you'll pay me, but if I burn your house down on purpose, you can't sue me, right? The court's going to say, yeah, that's enforceable. We're just going to cut out that exculpatory clause, that clause that excuses intentional conduct. We're going to cut that out and we'll enforce the rest of the contract. They find that it is severable, right? It's removable. We can cut it out and the patient will still live, right? We can cut it out and the contract still meets its essential purposes, all right? Here's a term you probably ought to know. When a court finds that it is able to edit a contract this way, when it finds that it's able to sever a part of a contract, we typically call this blue penciling, okay? Blue penciling. And It's just a term of art. Maybe if you understand where it comes from, it'll help you remember it. Used to be a long time ago, before we had word processors and all that kind of stuff, when people wanted to make changes to documents, right? When they wanted to edit, they would use pencils, right? And so if you typed up something and you gave it to me and I wanted to make changes, if there was a part I didn't like, I didn't just erase it or black it out, because if I did that, you wouldn't know what was changed. Instead, I would take here's a regular, I don't have a blue pencil, but I would take a blue pencil and strike through it, okay? That would show you that the blue pencil indicated that I am removing this portion and editing it, but you could still see what was taken out, all right? We don't use blue pencils anymore. We hardly use pencils at all. But that was the process. We called that blue penciling, and we still refer to it the same way. Okay, so if a court is presented with a contract, there's part of the contract that would be unenforceable due to illegality. But the court looks at it and says, you know what? That is severable. I can remove the illegal portion. I can take that out and still enforce the rest of the contract, and the contract will still have a purpose, right? It'll still meet its essential terms. Then I can blue pencil it. I can mark out that offending provision and enforce the contract otherwise, all right? Not in every contract, right? If I hire you to kill my brother, if we strike that part out, there's really no contract left, right? So that wouldn't be severable. In fact, that would just be illegal and criminal, and we're both going to jail. But if I hire you to work in my restaurant and I include some kind of a terrible, way overbroad, way unreasonable covenant not to compete, the court can just strike that part out and they can enforce the rest of the contract. That offending provision is severable, and we would blue pencil it. We would remove it and enforce the rest of the contract. Okay. All right, so that's illegality for right now. Let's stop because we're right at about an hour, and when we come back, we will talk about capacity. Capacity is also important, whether it's an element or a condition that has to exist. If you don't have capacity, you may not have a contract. All right, still another one of those waffling things in the law. Just because you don't have capacity doesn't mean the contract is unenforceable. But we'll learn about. We'll learn about more of that next time. All right, thanks. See you then.